SJC-13885, Louis Finfer et al. Versus Andrea Joy Campbell, Attorney General et al.
Okay, Attorney Goodhart.
Good morning, Chief Justice Budd. May it please the court. Lisa Goodhart with Shrish Cockerell. We represent 8 voters who challenge as unfair the Attorney General's summary of Initiative Petition 2518, which seeks to lower the tax rate on certain kinds of income from 5% to 4%. We ask the court to declare that the petition cannot appear on the ballot this November because the summary of the measure prepared by the Attorney General fails to satisfy the constitutional requirement of Article 48 that there be a fair, concise summary. I'd like to make 3 points this morning. First, I'd like to tell you precisely what's so unfair about this particular summary. Secondly, I'd like to tell you what's wrong with the Attorney General's argument about the nature and scope of her obligation in preparing a summary of a petition. And lastly, I'd like to address the intervener's argument that the defect in this summary is somehow a harmless error which can be cured by the availability of other information and political debate. So let me start by telling you why this summary is unfair. This petition, well, let me back up. Before we look at the tax rates as they currently exist, we have to start with an understanding that there are just 3 basic categories of taxable income under Massachusetts law. That's Part A taxable income, Part B taxable income, and Part C taxable income. And what this petition would in fact accomplish is a reduction of the tax rate for everything in those 3 categories that's currently taxed at 5%. And specifically, what that means is it would lower the tax rate for some Part A taxable income, that is the portion of Part A taxable income that consists of interest and dividends. That's number 1. Number 2, it would lower the tax rate for wages and salaries and everything else that falls into Part B. And by the way, if you go back to Section 2 of Chapter 62, you'll see that Part B is defined in part as everything that isn't Part A and Part C. So it's a big bucket, but wages and salaries is the heart of it. And lastly, this initiative would reduce the tax rate for all Part C income, which consists of long-term capital gains. So that's what it would actually do in fact. And what in plain English that would mean if the Attorney General chose, and I think she properly chose, not to speak to the voters in terms of arcane technical terms of Part A, Part B, and Part C, but in plain English to what would matter to them and what they would understand to be the practical effect of the change of the tax rate. What the Attorney General should have said, should have made clear in whatever words she chose, and she's got great discretion in how she does it, but the 3 main elements, the sum and substance of this petition, are a reduction of the rate for interest and dividends, wages and salary, and long-term capital gains. This summary.
But that's true unless the legislature ceases to tie the tax on Part C, long-term capital gains, to Part B.
That is correct, Justice Wendlandt.
So this initiative doesn't affect that tie, right? That nexus is not part of this initiative at all. So if the Attorney General had said what you propose, interest, dividends, wages and salary, and long-term capital gains, that fifth bucket, long-term capital gains, may or may not be true when the voters get this?
I would say two things in response to that. Number one, that interrelation has been an express part of Section 4 for the last 25 years, number one. Number two, when the Attorney General prepares her summary, she is to look at the law as it exists at the time. If I were here before you asking her to speculate that the legislature might make some fast revision to Section 4 between now and the election, that would be impermissible speculation about hypothetical, theoretical possibilities. The Attorney General's summary of necessity must take the law as it exists currently. And currently, that interrelation is clear and express, indisputable, undenied, and very clear.
Don't you have, what I found your strongest argument was that when I read the summary, particularly this, the proposed law would, over a period of 3 years, lower the tax rates on one personal income, blankety blank, personable taxable income other than interest, dividends, or capital gains. It's the other than interest, dividends, or capital gains. So not only do they leave it out, but that's bothersome to me, because my reading of that is capital gains is not included, right? It's not just a material omission, it's, in your view, it's a material misrepresentation, right?
That is precisely what is so fundamentally unfair about this summary, and what puts this summary in a different category than other cases where this court has tolerated trivial errors or omissions.
But I'm trying to, so I get that part of your argument, but I'm trying to figure out, we measure this by whether it would change a voter's views, right? I'm just trying to.
No, Your Honor. I think before you get to that, before you get to whether it changes a voter's views.
Well, it could change a voter.
Could, okay.
So
that's an important question. But in order to get to that question, the fundamental premise has to be a voter cannot make up her mind whether she's for something or against something unless she is given a fair summary and a reasonable comprehension of what it is she's being asked to decide.
This voter knows you're lowering taxes on dividends and interest, you're lowering taxes on salary, and then it's unclear what you're doing with capital gains. Or let me give because they're going to stand up and say it's unclear. But so I'm just trying to see the voter who it's less, you're getting more than, you're getting even a greater tax reduction than you think. And that's going to change your vote. I'm just trying to understand the logic here. And so, and the specifics are that people who sell a home or sell a stock that they've held for longer than a year, or sell a business, are going to get a greater tax reduction, right? I'm just trying to understand
Let me respond.
As Justice George says, the practical realities of this and how it affects voters.
To that point, Your Honor, the Constitution demands, and this comes from Sears, interpreting Article 48, that for a voter to make up their mind, and the reason why it's in 48 is because although the ballot initiative process is the people's prerogative, and the good people of the Commonwealth want to have the ability to have the laws they choose whether or not the legislature wants, they also wanted not to be asked to vote on anything without the benefit of a fair summary from the trusted voice of the Attorney General. So what the Attorney General has to give the voters is something that tells the voters what is it you're being asked to vote on. And I suggest to you, Justice Kafker, that where you have a petition that seeks to lower the tax rate on certain kinds of income, you have to tell the voters in broad brush what are the kinds of income that are subject
They
to this
do it,
reduction.
they do the rest of it, but they mess up or mix up the capital gains point. But again, there's going to be a lot of other information. That's going to be the centerpiece of a lot of the advocacy, right?
Points.
Go ahead.
1, getting it right on 2 out of 3 main elements does not pass constitutional muster. Secondly, as for the other information, it has never been this court's rule, nor should it be, that the availability of other information and the rough and tumble of political debate suffices to make up for an unfair summary. In all of the cases where this court has pointed to other information, the Secretary's Voter's Guide, the political process, the pro and con statements, the opportunity for political debate as correctives or mitigating factors that will help the voters understand. In all of those cases, the court first found that the problem, the defect, the alleged unfairness was not fundamental and did not go to the sum and substance of the measure. Where you have a defect that goes to one of the main elements, and I suggest to you, Justice Kafker, and to the court, the applicability to Part C, long-term capital gains, is one of the main elements of this measure.
Hey, can I ask you, putting aside the instance where we rewrote the summary, put that aside. All right, what's the remedy here?
Okay. The remedy here, and the Attorney General and the Secretary agree that the remedy here is to keep this petition off the ballot for this election cycle, again, because it cannot constitutionally go to the voters. Now, this does not mean that it can never come before the voters. The proponents are free to try again the next election cycle.
But why would that make sense, though? Because you go through the petition initiative, all the voters that signed up on it to put it on the ballot. The issue that you're complaining about is a summary of the initiative. There's no question that, or there's no concern that the petition itself violates Article 48. And that's what we've been doing all morning and what we're going to be doing all week. So we're talking about the summary here. Why isn't this, hey, back to the drawing board? There's plenty of time before the primary. Back to the drawing board, give us a summary that encompasses all of this.
The answer to your question, Justice Georges, is that the 80,000 petition signers did not rely on the text of the petition. Those 80,000 petition signers relied on this unfair summary.
How do we know that?
I think you have to assume it because that's what the petition presents them with. It's a single page with signature lines, and the only substantive information they are given when they are handed that petition in a supermarket parking lot is the Attorney General's summary, which would have told them that capital gains are excluded.
In the case in which we decided you couldn't remedy this, is it because there wasn't enough time for them to get the 80,000 again? I'm just trying to, because it seems like you could fix this and they could still have to get 80,000 petitions. But we seem to have ruled against that. But I'm trying to understand the factual context. Was it because there wasn't enough time?
Well, there's certainly not enough time here.
Why not?
Well, because the Constitution sets forth timeframes for certain things to happen, so we're stuck with that.
We're stuck, so we're past the time.
We're past that.
We're past the Constitution.
We're past that. If the proponents, upon certification of this unfair summary, had immediately come to this court and said, we recognize it's going to mislead the voters, this would be a different case. We're far past that. It's May 4th. There's no remedy. And this court has said so in footnote 26 of the Hensley.
And I take it they're going to stand up and say, you were also silent. The opponents were
Let me respond to that.
awfully silent, given the glaring language there. So what do we do with that?
Okay, so I start with the premise that this case doesn't get decided on who's more to blame as between the proponents and the voters challenging the summary. It is the irreducible constitutional obligation of the Attorney General to prepare a fair summary for the benefit of the voters, full stop. Secondly, if to the extent the proponents are suggesting that deciding this case, as we urge, would somehow create perverse incentives for opponents of initiatives to lie in wait and then come forward and sandbag initiatives, I think the perverse incentives that would be created by not keeping this off the ballot are worse, which is that proponents would sit by and not assist the Attorney General. They know best what their measure does. So if anyone has an obligation to assist in making the summary fair, it should be the proponents. And if they're not satisfied with the fairness, they have an opportunity to challenge it. Voters may not realize the defect in the summary, and that was the case here, until later in the process. And if and when they do discover a constitutional inadequacy of the summary, they may bring it forward under this court's case law, as long as they do so, and we did, in time for you to rule on it before the secretary has to publish the voter's guide. So that's my response to that question. And on that, I will rest on the briefs. Thank you.
Thank you. Okay, Attorney Golke.
Good morning, Your Honors. May it please the Court, Grace Golke, Assistant Attorney General, representing the Attorney General and the Secretary. Your Honors, this summary is not the once-in-a-century anomaly the plaintiffs suggest. This Court said in Anderson 2 that what the summary need only describe the amendment itself, and that is exactly—
I think it's a fair representation, a fair summary of what the petition would do.
I do, Your Honor, because what the petition would do is to change two different tax rates. We don't contest that there is a third rate that, as current law stands, would change as a collateral effect of those two
So
changes.
why is it fair? Why is it a fair summary to explain only two, but not the third?
Because, Your Honor, that is what the petition does. The petition changes two rates. And this Court has repeatedly said that where a summary closely tracks the language of the petition, that is a fair summary. And
well, hold on, sorry, isn't the petition?
But you used the word in response to the Chiefs that I would push back on. Use the word collateral. And as Justice Kafker in the question to Attorney Goodhart, this summary categorizes, if maybe not categorizes is the wrong word, but at least suggests that capital gains, that the effect on capital gains is an indirect consequence, when that's just not true. It's structurally automatic. So how could that be collateral?
Well, Your Honor,
How could that change be at all collateral?
it's collateral in the sense that it is not being accomplished by the petition itself, by the amendments that it is making and the provisions within existing law that it is changing. So there could be, I understand in this particular case, it is close in sort of space. You know, the provision that is acting as an effect of what is being changed.
But if the summary didn't say anything about capital gains, may be fair. But it does list capital gains, which for the last quarter century have been tied to Part B income tax rates.
Yes, Your Honor, and I think if capital gains had been mentioned gratuitously, that would be a different question. But capital gains is included within a description of a term of art that is used in the petition. So the petition refers to Part B income.
We're dealing with the average voter. Isn't the average voter reading this summary going to say, the proposed law would lower the tax rates other than on capital gains income? I'm not a tax lawyer, but isn't that sort of what you suggest here, or come more than suggest? I mean, I get it if you'd left it out altogether, but you've got some language in here that says the opposite of what is happening, which is that capital gains is going to drop from 5 to 4.
Your Honor, I think the concern is that if it had been left out altogether, then there would be no definition of what Part B income is.
Sure,
which
there would
is
be. There
itself
could be
defined.
salary and wages, which is the lion's share of Part B income.
Well, Your Honor, that too would be inaccurate because it is not the only aspect. There's also things like rental income, gambling and winnings, alimony. There's all kinds of categories.
But that sort of seems to fall within the rubric of what's a concise and fair summary, right? You don't have to describe all the details, but the lion's share of Part B for most people is wages and salary.
Well, I think, Your Honor, that there may be multiple fair ways to
Right, that's why I was zoning in on the listing of capital gains as suggesting not capital gains, which is
Your Honor,
not going to be true unless a quarter century of existing tax law gets reversed between now and the vote.
Well, I think, Your Honor, that is a product of the structure of the tax code, that there is a difficulty in easily summarizing this petition. I will grant that. It's a petition that looks deceptively simple. Many of the petitions that this court sees is many pages.
I don't think the Attorney General had any sort of malintent, and I get that the point was to not list Part B, right? Because nobody would know unless you're a tax lawyer what Part B is. The problem is the way it's described leads to a misimpression, I think, among the average voter that this is not going to have an effect on long-term capital gains or short-term.
I understand, Your Honor. I think that in the effort to provide as accurate a description as possible of Part B income that was still concise, this is the way that the Attorney General thought was would most accomplish that goal. And so long as I think this court has pointed to other sources of information that for these things that happen as a result, so things that happen outside the four corners of the petition, this court has said that there are many other sources of information, both the for and against statements. There's also the statement by the administration and finance that goes into the information for voter guides.
If we think this is confusing at best on capital gains, we can still send this to the voters because it wouldn't make a difference, because Ms. Goodhart argues that the AG has got such a high status that they're going to be, all their advertising is going to run up against the fact that you put in the words other than capital gains. How do we address that?
Well, Your Honor, we would say that this summary is accurate as written.
I find this summary is not great. So I think that's a tough one. At least the other than capital gains is not helpful in this context. So
Can I just pile on to that? You referred to the actual text of the measure as being simple, and I agree that it reads really simply, and it conveys no information that could cause a voter to be able to tell who's right. The AG says it does not cover capital gains. Then you're going to have for and against from like other people who don't have those credentials, and then they'll have the measure, but the measure doesn't say. Isn't that a problem? Because I think there are other cases we've had where there's a summary that arguably was ambiguous or something, but the voters had the measure in front of them and they could tell.
Your Honor, I suppose, and maybe this is a losing battle, but I contest that, or I don't agree that the Attorney General's summary says there will be no effect on capital gains. What it says is that there is a category of income, which is defined in the tax code as excluding capital gains, which will be changed.
All right, well, I mean, I don't know that we need to debate that point, but as a matter of English, I'm not sure that's a fair reading. I have a more simple way of doing this. I recognize that the Attorney General has the ability and probably even the responsibility to explain the initiative in some kind of understandable way for the voters. But here, and I understand that the Attorney General thought that just saying Part B or Part A to describe the initiative would be inadequate. But it's the Attorney General who introduced the words capital gains. Those words, I don't see them in the initiative petition. So once the Attorney General decides to introduce this concept into the summary, why isn't it then that must be accurate. The effect on that term or how that term plays into all of this must be accurate. You know, this is not something that was driven by the language of the initiative petition itself. That's where my rub is. Once you take that on, don't you have to do it correctly?
I will, I won't push back on whether it has been done correctly or not. What I would say, Your Honor, is that the line of demarcation in this court's cases of what goes into the summary is what does this amendment accomplish? And what does it accomplish by its terms, not what is accomplished in existing law. I'm looking at—
Sorry, can I just interrupt you right there? Because your summary already takes into account existing law in all kinds of ways. The measure doesn't change the definitions of Part B, Part A income, but your summary relies on other provisions of law that define those terms. For example, that Part B includes wages. And so why is it that you were accurate in incorporating into what is Part B in effect, which is a good choice to do, to be clear what that means, and yet you did not include the obvious implication with respect to Part C?
Your Honor, I would say that the Attorney General does not need to be blind to existing law. Obviously, in order to explain what the petition does, there will be a necessity to look at existing law in certain regards. But the line of demarcation that this court has said is it something describing the amendment itself, or is it, and then there's all kinds of descriptions of what is not required to be in the summary. And I think that's a different question from, is it precluded from ever appearing in a summary, but what's not required? And those
So
are things like—
what do we do if this is confusing at best? You say it's a description of a category, Part B income. Could be read to imply that capital gains is not going to be affected, and it will be. What is the solution? Do we pull this? Is this required to be pulled as suggested by the petitioners?
Our position is, if this court found this fundamentally unfair, so unfair it could not go to the voters.
Well, that's the question I'm asking you.
Well, I suppose
it's confusing at best. Go.
Right. I think confusing at best, to me, that articulation sounds to fall more within the category of cases where this court has said, nonetheless, there are other forms of information available to voters that would clarify and that would provide that type of advocacy information about what might happen as a result of this measure. I don't think there is a solution.
Tell about those cases. Describe the cases where there's something that's either confusing or wrong in the summary. We said it was okay, and why that's analogous to this.
Yes, Your Honor. Let me just find them. The ones where that came up, I believe Hensley was one of them, related to the legalization of marijuana.
Wasn't that a gap in the summary as opposed to sort of confusing language in the summary?
It was also related to a term being not being defined in the way that the court thought would be most helpful to voters. I believe the term was marijuana products in that case, that the court was of the opinion that that could have been defined in a way that was more understandable to voters, but that the assumption was that other sources of information would clarify that for voters. Another, I believe, that in Mass Teachers Association, that's the 1981 case, there was a particular provision that was described as obviously a substantive change in the law, but it was still not considered to be so flawed as to prevent the measure from going to the voters. In that case, I believe it was a challenge after the measure had already gone to the voters, so it's a little bit different, I will concede in that sense. And then there's all kinds of cases where there might be some disagreement about what the voters need to know in order to make a decision. So Mazzone, for example, that's the 2000 case related to changes in drug treatment trust fund, that the proponent or the opponents in that case suggested that as a result of this measure, effectively it would decriminalize certain types of drug use or even drug trafficking. And the court said that if opponents believe that this measure will have some impact that was not necessarily intended by the proponents. And I would say, I don't think on this record we can assume that the change to Part C income was intended by the proponents. I don't know one way or the other. And that's exactly why the Attorney General's role is limited to the amendment itself, because if she starts to assume what is and what isn't intended outside effects, that draws her into the partisan process.
Well, maybe,
I'm sorry.
sorry.
If we find the summary unfair, is there a do-over?
No, Your Honor, I think that would be, moving from Justice Wendland's question, if it was so far, if the court found that the summary was so unfair that it could not go to the voters, Hensley, I think, was quite clear, and that was a position of the Attorney General's office, and that was adopted by the court, that because of the constitutional timelines and requirements, it simply can't be adjusted at this phase.
Why don't we hear from Attorney Martin?
Thank you, Your Honors.
Good morning, Your Honors, and may it please the court. I have 4 minutes to make what I think are 6 very important points in response to the questioning this morning, so I'll try to move through them quickly. First, we fundamentally disagree that this is a misleading summary. If you look at the summary, it points out as a whole that the petition will reduce tax rates, plural, on 2 categories of income: 1, interest and dividends, and 2, income that is not interest, dividends, or capital gains. As we point out in our brief, a reasonable voter looking at that language will see that they're being told in 1, that tax rates will be cut on interest and dividends, and in 2, that they will not be cut on interest, dividends, or capital gains.
Doesn't that make it, and you're going to get more time, so don't panic. But so doesn't that make it even more confusing?
We do.
And I saw your argument. Okay, they're going to be on alert that this is kind of confusing, but isn't this just more confusing?
We think it's not, Your Honor, because we think a voter looking at that language and the way that it's presented will understand that they're being told that there are 2 categories of income for which the tax rate will be cut. 1 is interest and dividends, and 1 consists of types of income like wages and salaries that are not interest, dividends, or capital gains. So they'll understand that when it says not interest, dividends, or capital gains, that is not a universal statement about types of income for which rates will not be cut. Otherwise, category 1 makes no sense.
But that language makes it sound like capital gains is excluded.
It does not, Your Honor, because it's defining the category, and the category consists of income that is not interest, dividends, or capital gains.
So do you disagree with Attorney Goodhart's when she started out her argument that there were 3 threads of taxable income streams here, right?
So the general laws create 3 types of income. Only 2 are addressed by this petition, and this is very important.
Well, that gets to my point. So, but 3 are being changed, and they're only being told about 2. And so when we talk about what our case law has been, what our jurisprudence under Sears, and talk about what these summaries have to say in these main outlines, you've got a guaranteed automatic effect on one of the 3 core income streams. And it makes it sound as if that's exempted.
So, Your Honor, it is not guaranteed and automatic. And I want to focus on how Section 4A and 4C both relate to 4B, because this is important. The people who put together this petition wanted to make sure that Part A income consisting of interest and dividends would be subject to the tax cut. And so while Section 4A currently also cross-references 4B, they didn't just rely upon the cross-reference to ensure that the rate would be cut for interest and dividends. The petition directly addresses 4A and provides that there will be a new 4% rate for type A income consisting of interest and dividends. Now, for 4C, it doesn't say anything. And so, because the petition is completely agnostic about what happens, and if the legislature were, between the time this was introduced last year.
Well, it's agnostic because Part C is tied to Part B. So it doesn't need to do anything with respect to Part C.
It would if it wanted to make sure that the legislature could not uncouple 4C from 4B and keep the 5% rate.
There might be different interpretations as to why petitioners decided to structure their initiative petition in this way. That doesn't really dictate the Attorney General's obligation in terms of summarizing
And,
petition.
and so, Your Honor, the Attorney General's obligation, this court has made clear repeatedly in cases like Alcusa and Hensley, does not include a requirement of pointing out all the implications of existing law as a result of changes brought about by
You would
the
have to
petition.
have the legislature, after it was enacted by the people, to decouple capital gains, right, from property.
They might have done it last December, Your Honor. I mean, this petition has been out there for a while.
We've had longstanding law for 25 years. It would have to be changed in order for the summary to be accurate.
Well, no, and this is, again, just like Alcusa and Hensley. There are lots of examples of petitions which have implications under existing law. This court repeatedly has said that the summary does not need to describe all of the implications flowing from existing law, even if they're longstanding.
The problem
Alcusa,
is
for example,
it's not describing all the implications. It's trying to describe something that is actually not going to happen unless there's a change in the law. So I understand your argument that this is describing two categories of income, Part A and B. And Part B, confusingly, is described as anything that's not A or C. And because C is capital gains, that the Attorney General was trying to do her best to summarize what Part B is. But as a result, there's this, and you said it in the beginning of your argument, there's this implication that not capital gains is going to be affected, and that capital gains will not be affected by this law. And it will be unless, there is some change in the last quarter century of the law.
As matters currently stand, there will be, but I think that was no less true, for example, in Alcusa, where you had longstanding employment laws that would have been changed by the new categorization of gig drivers.
Was that, I'm sorry, and just remind me of the summary in that. Did that summary suggest that there would not be those changes?
I don't think it said there would not be those changes, but
See,
again,
that's
we're
the
not
problem,
reading this.
because this summary suggests that there will not be those changes.
And Alcusa doesn't quite help you because we said that initiative didn't go forward, right? Because it left out a material provision, which was the second part of the decision said not telling people about tort liability is important.
Well, as to
Isn't that comparable to not telling people about capital gains or telling them wrong about capital gains?
Well, no, Your Honor, I think that had to do with the, I'm not sure that was the summary. Maybe I'm misremembering the case. You would know better than me.
No, it's a long time ago.
Yeah. Now, let's say there was a mistake or an error. Ms. Golke already addressed this. If you look at decisions like MTA or Hensley, this court has made clear, I think as Justice Kaffer, you may have been suggesting, that you need to look at the actual practical effect on voters of the potential change. MTA, when it was describing this court's prior decision, in opinion of the justices 1970, said, for example, that while omitted matters standing alone may be significant, the majority, in opinion of the justices 1970, concluded that under the circumstances of the case, looking at the measure as a whole, they were not. And here we would point to the plaintiff's own complaint, which makes clear that this Part C impact is a relatively minor segment of the fiscal impact of the measure as a whole, about 7%. And I think if you go back to the Mass Teachers Association decision,
How does that bear on whether the average voter would find this confusing as opposed to whether the average voter would find this important?
because it's not just a question of whether it's confusing. I would point the court to what it said in Hensley, for example, which is that an error or omission, so let's say there's something wrong with the summary, an error or omission must be assessed in the context of the entire proposal and its likely impact on voters. So even if you find that there's a problem with the summary, that does not mean that the summary is constitutionally defective. It does not mean that this measure is excluded from the ballot. You have to
How
look
do
at
we
whether
know what, how do we know? There's no, like the equivalent, there's nothing like the equivalent of consumer surveys here, where we have any information about how the man on the street might understand this.
So I think,
how are we supposed to get to that?
I think MTA is a good guide here, Mass Teachers Association, which was another tax case, because you think about how a voter approaching this measure is likely to view things, right? So someone who's likely to vote against this measure, they don't want the tax cut, is not going to say, oh, but it also, it's not likely they're going to say, also there's this small amount that will be cut as a result of Part C income. Now I'm in favor of it.
But both of you do a good job of showing sort of, okay, she's saying, voters may be affected because the rich are going to benefit the most from the capital gains. You respond, I thought, well, saying, no, it deals with sales of small businesses. It also deals with sales of houses. Those are three sort of potentially important types of decisions people will make affecting how they're going to benefit from or lose from this tax thing, right? Are those meaningful to a voter to understand that?
I'm not going to deny that there may be some voters who care more about one than the other. What I would say, though, is if you look at Mass Teachers Association, if you look at Opinion of the Justices 1970, there were always going to be, under this court's precedents, aspects of a petition which are not mentioned, which might in theory be important to some voter. That does not mean that the summary is constitutionally defective. And the 1970 decision is great because there you had a split in the court. There were some very vociferous dissents which said, hey, there are aspects of this amendment to the Constitution which might be important to some voters. They're not mentioned in the summary. And what the court said was, as long as the summary mentions the main features, the features that are most likely to matter to voters, then that's sufficient. And so here we're on their own complaint. They acknowledge that the summary addresses 93% of the likely tax impact.
I don't care about, I mean, the legislature cares about the total dollars. Voters tend to be focused on themselves. And if they're selling a house, they're going to care about this, right?
Well, and this is what, I mean, this is where I think the fact it's 93 and 7 matters, because it seems unlikely that voters who want a tax cut are going to give up 93% of the tax cut in order to stop themselves or potentially other people from getting the 7% of the tax cut. And you're allowed to take into account that real world intuition under decisions like Mass Teachers Association and Opinion of the Justices. I do want to talk about the other information that's available. Because this court repeatedly has said, including recently in Hensley, that as long as the additional facts are likely to get to voters through media, through the Information for Voters Guide, then even if there's some language in the summary itself which may be confusing, it still gets through.
How do you address the special status? The AG's perceived to be the neutral. So how do you address the fact that the AG's language is going to be front and center of all of this?
Right, and I think that's directly addressed by cases like Hensley, where the court found that language in the summary was confusing, and nonetheless, in Hensley, pointed to the additional information available to voters and said that will take care of things. There's just one more point I want to make quickly, which is that this is not the only cross-reference to Section 4B that exists in the general laws. There are other cross-references to Section 4B out there. Chapter 63, Section 2B, Chapter 63, Section 32D. The existence of these other cross-references has come out in the press, for example, recently. And so this just goes to show, one, that these other sources of information will wind up flagging information for voters that they may think is important. And two, if you were to include every single cross-reference to Section 4B, this is no longer a concise summary. And that's part of the reason why in other cases like Hensley, the court has made clear that statutory cross-references do not need to be mentioned.
But you're making this sound like it's sort of a game of hide and seek, and that's not what the purpose of the AG's summary is.
No, it's certainly not, Your Honor, but this court has said, I mean, if you read Sears by itself, you might read Sears and think everything has to be mentioned. Subsequent cases like Opinion of the Justices 1970 and Hensley have made clear that really only the major features have to be mentioned.
The question is whether this is a major feature. And so
it's not even mentioned in the petition itself. The legislature could get rid of it if they wanted to, and it's a very small dollar figure in the universe of the measure.
okay. Thank you very much.